page 7. Is that working for you, what you see on your screen?
I have mine printed, so you don't have to worry. It's mainly for them.
Okay, can someone put in the chat box? Jameson, I see you. So can you let me know, how does it look on the screen? Is it good, not good?
It has 3 backgrounds. It has your
Okay.
your screen, and then it has the Zoom, and then it has the contract. Oh,
Okay.
now it's deleted the Zoom.
Is that good, or you
Yeah.
guys still see my desktop, my very messy desktop? Sorry.
You can still see your desktop.
Sorry. How's that?
That's better. We still see a little bit of your desktop, but that is better as far as being able to read.
Yeah, sorry guys, you know, those desktops. Yeesh. Let me see what I can do just to kind of clear it up a little so you're not looking at everything. Is that a little better?
It's just about a 2-inch panel on the right side of the contract.
Jameson, is it driving you crazy, or am I good?
You're good.
Okay, thumbs up. All right, awesome.
You're good.
Okay. Okay, so we are day 2 of contracts. Welcome everybody. Karen Campbell, our branch manager in Camarillo, is our host and teacher for this second day of contracts. So we are continuing our buyer documents from day 1, and we are just wrapping up page 7 of the RPA. So if you missed it, just a reiteration, all of these sessions this week are being recorded, and I will be uploading them on our YouTube channel later this week, and I will send a company email letting everybody know that link. So Karen, you're on.
All right, well, let's get started. I'm excited to be here this morning. Welcome everybody. We are continuing on the RPA on page 7 of 10, number 20, which is joint escrow instructions to the escrow holder. So with that, we'll get started. So joint escrow instructions to the escrow holder simply means that the contract is going to be used as part of the escrow instructions that the escrow company will be putting together. So they're going to give you a copy of the signed contract. They are going to sign the back of the contract, and they are going to put all of their provisions and all of their disclosures along with this contract as part of your escrow instructions. And B is a copy of this agreement, including the counteroffers or addenda, shall be delivered to the escrow holder within 3 days of acceptance. Or if there's a problem where they maybe don't have them signed or something, then you can put a time frame in there. But basically the buyer and seller authorizes escrow holder to accept and rely on copies and signatures as defined in the agreement originals. And it basically just gives a provision in there so that your escrow company can make sure that they get all of the contracts back and forth, the counteroffers and all of the addendums that go along with the contract, which becomes part of the escrow instructions. Okay, next page, page 8 at the top. Brokers are a party to the escrow only for the sole purpose of compensation. And that's in your escrow instructions. It's also in the contract. Just want to back up. You always want to date at the upper right-hand corner. You always want to put the date that the contract was written on every single page. So remedies for buyer's breach of contract. Any clause added to the party specifically remedy, such as a release of forfeiture of deposit or making a deposit non-refundable for failure of buyer to complete the purchase in violation of the agreement, shall be deemed invalid unless the clause is independently satisfied the statutory liquidated damages requirements. So that's just a disclosure saying how that works. I typically do not read that to them, but what I do read to them is liquidated damages. I read the whole paragraph so that they understand what their earnest money deposit is and that it is subject to liquidated damages. The liquidated damages, if the buyer fails to complete the purchase because of the buyer's default, The seller can retain as liquidated damages the actual deposit received. If the property is a dwelling with no more than 4 units, one of which the buyer intends to occupy, then the amount retained shall be no more than 3% of the purchase price. Any excess shall be returned to the buyer. The most important thing is that at the time of any increased deposit, the buyer and seller shall sign a separate liquidated damages provision in according to increased deposit as liquidated damages. So liquidated damages simply means that everything is moving forward in the contract, and within those 17 days after the contract contingencies have been removed, if that buyer wakes up and decides that they just can't move forward with the contract, then the seller can hold their deposit as liquidated damages and or sue them up to 3% of the sales price. So I always make sure that they understand, they being your buyer, understands that that is a contingency and that is the risk that they take when they put that earnest money deposit in escrow. Number 22, mediation. Mediation must happen if there's a dispute between any parties in the transaction. A mediator is a party of someone who has been in the business, either a retired judge, it could be a retired realtor, a broker, anyone that's a mediator through the Bar Association, someone that can listen to both sides and come to a determination and try to help the two parties agree on what the problem is and then try to resolve that problem. So I always say that mediation has to happen before arbitration or before going through the court system. So arbitration of disputes, the parties agree that any dispute or claim in law or equity arising from between them out of this agreement or resulting in transaction, which is not settled through mediation, shall be decided by a neutral binding arbitration. Arbitration is usually a group of 3 people, usually volunteers through the arbitration Department of Law. We have them through our association as well. But they're a party that is going to listen to both sides. You don't give up your right to discovery when you go to arbitration. You can submit all of the facts to the dispute. And then the thing about arbitration is it may not be appealed. They can award money and the decision is final. So I always let people know that they have the right to do arbitration or not. And you always want to make sure that you don't highlight the buyer's initials or the seller's initials at arbitration because it's a voluntary thing. They have the right to do that or not. If you highlight something when you're highlighting your contract, if you highlight those 2, it is assumed that you have encouraged them to do that, not giving them the right to do that. So arbitration is very important. If they don't go to arbitration, then they do go through the court system on a dispute, and sometimes that takes a very long time. Preservation of actions. The following does not constitute a waiver or violation of the mediation or arbitration provision. In filing of a court action to preserve the statute of limitations, the filing of a court action to enable the recording of notice of pending action for order of attachment, receivership, injunction, or any provisional remedies, the filing of a mechanic's lien. So those are all the ways that you can go to arbitration for those things. Broker is not obligated or compelled to mediate or arbitrate unless they agree to do so in writing. So that is between the buyer and seller only. Selection of service providers. Brokers do not guarantee the performance of any vendors, service, or product providers. It used to be years ago that we were responsible for everybody, and then the contract was changed so that now everybody's responsible for their own profession, which is a good thing. Multiple listing service. The brokers are authorized to report to the multiple listing service a pending sale, and upon close of escrow, The sales price and other terms of the transaction shall be provided to the multiple listing service. We're required also by our rules and regulations of the MLS to do that as well. Attorney's fees. Oh, somebody's not on mute. Attorney's fees in any action, proceedings, or arbitration between the buyer and seller arising out of this agreement, the prevailing buyer or seller shall be entitled to reasonable attorney's fees and costs for the non-prevailing buyer or seller. It just spells it out ahead of time. Assignments, the buyer shall not assign all or any part of buyer's interest in this agreement without first obtaining the separate written consent of the seller of the specified assignees. So sometimes you'll see a buyer will say their name and assignees. A lot of times when they have an LLC or they're part of a corporation, they may be the person that is making the decision, but it could be that somebody else is going to be the buyer in the property. That has to be in writing and it has to be on a separate form. And that form is an AOAA. We'll probably get into that in a couple days.
What?
Karen, I'm going to interrupt everyone who's attending. If you could please make sure you're on mute, please. Thank you so much.
Okay, equal housing opportunity.
Love you.
The property is sold in compliance with federal, state, and local anti-discrimination laws, of which you've already signed, and we've already gone over the fair housing disclosure. Terms of conditions of the offer. This is an offer to purchase the property on the above terms and conditions. The liquidated damages paragraph and the arbitration of dispute paragraph is incorporated in this agreement if initialed by all parties and incorporated by incorporated by all parties that have been reached. The seller has the right to continue to offer the property for sale and accept other offers at any time prior to notification of acceptance.
Hang on.
This offer is accepted and the buyer subsequently defaults. Buyer may be responsible for payment of broker's compensation. This agreement and any supplement, addendum, modification, including any copy, may be signed in two or more counterparts, all of which shall be contingent on the same writing. So basically what that says is that once you've sold the property and if the seller accepts another offer, you're still due the commission. Time is of the essence. Entire contract and any changes. It simply means that once you've signed this offer, everything will go into motion. Definitions, I typically don't go over those. I let them read those. And then expiration of offer. The offer shall be deemed revoked and the deposit, if any, shall be returned to the buyer unless the offer is signed by seller and a copy of the signed offer is personally received by the buyer. And then you need to, or you can put your name there if you're the one that's going to accept the offer. I typically don't put my name as an agent there because then you be responsible for when things happen, when it was delivered, when it was presented. I always
Karen? We lost your audio, Karen.
I see. It muted me again.
Okay.
So I'll just go back to expiration of offer. The offer shall be deemed revoked and deposit, if any, shall be returned to the buyer unless the offer is signed by the seller and a copy of the signed offer is personally received by the buyer. It says or by. That is a spot for you to put your name in there if you choose to be the one that's going to move the offer back and forth. Make sure that it gets delivered and make sure that it gets accepted and confirmed. If you don't put a time frame in this spot, then it's 3 days after the offer is signed. One or more buyers is signing this agreement in representative capacity is not for him, her, or the individual. If there's somebody signing on behalf of somebody else, again, you have to sign a capacity form, which is the RCSD. And then the buyer signs it at the bottom. Page 10 of 10, acceptance of offer. Seller warrants the seller is the owner of the property and has the authority to execute this agreement. It happens every once in a while that a seller is not the person that should be signing the offer. If it's in a trust, or if there's power of attorney or something like that in the contract, then that person may not be the one to sign this contract. And then may have to go back and have everything signed again. Confirmation of acceptance. A copy of the signed acceptance was personally received by the buyer or buyer's authorized agent on that date. It has to be confirmed in order for it to be accepted. And the initials go on the left-hand side, and the date and time go in that paragraph. Real estate brokers, the next part, you need to, down where it says buyer brokers firms, you need to put Century 21 Everest. You need to put your name, your license number, and sign it. And then escrow, once you have sent everything to escrow, escrow will do the acknowledgement and send that back to you. That is the confirmation of the offer. And a lot of times buyers miss the acknowledgement on page 10, but there's initials at the very bottom. You need to make sure that that is initialed. Let's see if there's any questions. There are not, so we'll move forward. So buyer's inspection advisory. This advisory is everything that the buyer is going to do to investigate the property. I'll just briefly go over it. The general condition of the property is going to be done by your inspector, and he's going to inspect all of the mechanics of the property. The square footage, the age, and the boundaries are typically done by the appraiser. Wood destroying pests are typically done by your termite report. Soil stability, existence of fill or compacted soil. If you are selling something on a hillside, you may want to get a soils report. Water and utilities, well systems and components. If you have a septic system, you may want to get a certified copy of the certification that the septic tank is in working order, and also that it is certified in good condition. And a lot of times the lender will also require that. Environmental hazards. Your NHD report will typically have your environmental hazards on there. Earthquake and flooding, that is also an NHD. Fire hazard and other insurance issues, that is also on the NHD. Building permits, zoning, and government requirements, that is on your city report, and most cities have a city report that the seller needs to provide to the buyer. Rental property restrictions, typically the seller will tell you that, but you can also check with a property management company to see if there's any restrictions that apply to the transaction. Security and safety. State law may require the installation of barriers, access alarms, self-latching mechanisms, and other measures to decrease the risk to children. So when you have a piece of property, if you see bars on the windows, they need to have a latch that completely unlatches them if you push them open. And those are the kinds of things that your inspector will also bring to your attention. Neighborhood areas, subdivision conditions, and personal factors, that will be addressed on your title report. And also you can check the crime rates and check for any kind of diseases or any kind of hazards You may want to go to the property at different times. You may want to look around the property within a square mile just to see if there's any cemeteries or any kind of condition that you're not happy with. And I encourage people to do that all the time. And then you just sign the bottom of the advisory. Next form, the coronavirus addendum and or amendment. This is another form for coronavirus. We've gone over several of them. This particular one is made part of the purchase agreement. So it basically states that we are in a pandemic, that the form is intended to contractually address unforeseen coronavirus circumstances. So this form will allow the buyer and or the seller to give notice to each other if there's a circumstance with coronavirus, if somebody has coronavirus or somebody is harmed by the coronavirus by cancellation of work or whatever the case may be. This is the form that you would use to extend escrow, to extend time, or to actually cancel the contract. Next page. This is a Century 21 Everest disclosure. It basically is disclosing all the different companies that have home warranty and inspections. Anytime you give a name and number to a buyer, you want to make sure that you're giving at least 3 names of different people that do the specific job. This form helps you with that. It gives you an idea of how many home inspectors and how many home warranty companies that we're giving, also termite and mold companies. So if you give this form and get it signed, which I recommend that you do, it will take care of that problem for you. And all of these companies have been given by people that are in our company that have used them in the past, and it honestly tells you what cities they serve and how to reach them.
Karen, I also want to interject. It's important for agents to know you may be wanting to be very incredibly helpful and offer to make appointments with the inspectors or of any kind for your clients, but please don't. It's their responsibility to make the appointments and have the appointment and invoices directed to them. Nothing with your name on it.
Well, and that point is well taken. Anytime you order an inspection report or a termite report, mold, whatever it may be, and your name is on it, the report covers you, not them. And so you always want to make sure that it has the buyers and sellers' names on these reports. And like she said, you want to let them order it. You don't want to be the one to order it. You want to pass on the liability and responsibility to them and have the contract between the company and them, not you. Very important, because if it ever goes to court, they want to know why you were the one that have your name on it and why you ordered the report and not them. Because remember, you're not a party to the transaction, they are. This is a great form. This is a summary of offer form. And basically what it does is it gives you the opportunity to give the facts, the most important facts about an offer on one form. And you can do this for every one of your offers if you have multiple offers and trying to weed through and decide what the best points are of the offers. It basically gives the purchase price, the initial deposit, any increased deposit, what their loan amount is, when the close of escrow is, the contingency of the loan, whether it's removed or not, or whether it's 21 days, the appraisal contingency, and if there's any property that needs to be sold prior to selling this property. So this is a great form. I was going to say it's fairly new, but
It's fairly new.
Yeah, it's fairly new because we used to have to do this on a spreadsheet ourselves.
Yes, which I still have. I have
Which
created.
I still have also.
But for any of our newer agents who've never written a contract or what have you, see these RPA paragraph numbers. So these tell you exactly where to find the purchase price information. It's on the RPA, which is Residential Purchase Agreement, page 1, item C, 3G. So it gives you exactly where to find that information.
So any questions before we move on to, we finally caught up. So now we will start our day two.
Day 2 program.
Day 2 disclosures. It doesn't look like we have anybody in the chat for questions, so we'll move forward.
Okay, give me 1 sec. You guys get to see my crazy screen. Sorry.
There we go.
Just make this bigger. As big as I can get. How's that?
It's good. And then go all the way to the top. There you go.
Okay.
Perfect. Perfect. So this is a fairly new form as well. It's the California Consumer Privacy Act Advisory. And basically it's a disclosure about personal information. So the thing that I want you to know most about this form is when you have a buyer or seller sign anything, you never throw it in the trash. You always put it in the shred. Anybody that would happen to come and take something out of a trash can and find somebody's signature that they can copy, you can become liable for that. So make sure you don't throw anything in the trash can, that you always shred anything that has to do with the multiple listing service, any personal information, any signatures. Hopefully you will not take any social security numbers for Fripta. Let escrow handle that kind of thing. But this form actually advises them and lets them know exactly what our policy is for personal information. I just simply say that our MLS is not a personal information system and we are not considered a covered business. So multiple listing information does get disseminated to all kinds of people, especially agents, brokers, and appraisers. And so that would make it so that we wouldn't have to worry about that kind of information, but still don't throw that in to the trash can. Always make sure you have a shred pile and put that in the shredder. You just have your buyers sign that form. Buyer's inspection waiver. So in a transaction, if you have a client, especially in this market, you have a client that wants to waive their inspection, you want to waive the pest control report, maybe the sewer lateral line if you're selling something in Ventura, you just want to buy the property, you want to buy it as is, and you waive all of your inspections, you must have this waiver inspection form signed. And it must have the initials after each home inspection waiver, the wood destroying pest waiver, which is the termite report, and anything else that they are waiving. This is the form that will actually help you stay out of court when something's wrong and they go, you didn't tell me I needed to do that. And if you don't have a waiver, you're the one that's responsible and you will be called to court along with the buyer and seller. So make sure that if something is waived, that you make sure that you sign this buyer waiver inspection report. Statewide buyer and seller advisory. The good news is they only have to sign at the end of this form, which is 14 pages long. I'm going to go over the highlights and just kind of tell you how I present it to a buyer and or seller because it's for both. I go over the buyer's rights and duties. The physical condition of the land and improvement being purchased is not guaranteed by the seller or the brokers. And the seller's right and duties for material facts. The seller is required to disclose all material facts. Broker rights and duties. Brokers do not have expertise in all areas and matter affecting the property. For your evaluation, you must have inspections to do all of that. Next page. it gives you a table of contents and tells you all the types of things that need to be investigated when you're purchasing a piece of property. So investigation of physical conditions, it can be easements from your title report, environmental hazards from your NHD report, any kind of geological hazards from your NHD report, inspections, pets and animals is your SPQ. So your SPQ is a form that your seller fills out to tell everybody that there's a pet in the property and there could be, pee spots or whatever on the carpets and or the floors.
So Karen, I'm sorry. So let them know what the acronym of SPQ is.
Oh, it's the Seller Property Questionnaire. You get
right.
We do, and we just say what we say.
So the seller documents we're going to be covering starting tomorrow, just so everybody knows.
And that's a very important form. So basically, what this statewide buyer and seller form is doing is it's trying to tell you all of the reasons and all of the things that you should investigate in purchasing a property. And then the SPQ, which is the Seller Property Questionnaire, what you'll get tomorrow is the seller will also be enticed to write down anything and everything about the property that they can think of, especially plants, pets, any kind of environmental hazard, anything that they know about the property they have to disclose. So basically these forms are disclosing to the buyer and seller everything they need to know in order to get the property sold and make sure that everybody has done their due diligence. Property use and ownership, you're going to pull a city report, which will have your building permits and zoning. It will state whether it's in a historical district or not, or whether there's an overlay in an area that is historical, but not each property is hysterical. I say hysterical, historical. You're going to check any kind of building or improvements to the property and make sure they're permitted. The title company is going to make sure that there's nobody else interested in the property or have a value interest in the property. You're going to make sure that there's security and safety, that there's, if there's any water shortages in the area, those have to be disclosed, and usually that's on a city report. Off-site neighborhood conditions, if there's a golf course around, you may have the problem of golf balls hitting your property. You want to make sure that if there's any high-speed rails or railroad tracks or river bottoms or anything to do with flooding, schools, anything like that, you want to check all of those things out.
Quick question. Does this apply to a mobile home also? City reports?
Yes. It does apply to a mobile home also.
City reports, okay.
Yes. If there's been a death on the property in the last 3 years, it has to be disclosed. If there's been a death on the property that's been a serious death, like a criminal death, you should always disclose that no matter what, because I'll tell you, your neighbors, the neighbors around that property, when your buyer moves in, the first thing that neighborhood is going to tell them is everything that's ever happened there. So if you've not disclosed it and the seller has not disclosed it, the buyer's neighbors will absolutely come over and say, did you know there was a sex offender that lived here before? And that's the first thing that's out of their mouth. So always make sure that you're helping the seller understand that they have to disclose any and all material facts. Any flood hazards, any fire hazards, all of that will be on your NHD report. Any liquidated damages, mediation, arbitration. If there's a lawsuit that the seller or buyer is in, that must be disclosed. Any other factors affecting the property, any community enhancements or private transfer fees. We went over private transfer fees yesterday, but a private transfer fee is a fee that the builder puts on each property so that he helps recoup some of the fees that he has had to pay to build the development. Associations, HOAs, CCNRs, all of those need to be looked at, and due diligence needs to be done with that. I always recommend that you rekey the property at the end of the transaction and make sure that the buyer is aware of that. A lot of times a home warranty company will pay for that. It's part of their home warranty. Just make sure that they are aware of doing that when you're transferring everything over. Investigation of physical conditions, easements, and encroachments. Those will all be on your title report. Environmental hazards will be on your NHD report. Will also be on the termite report if there's any kind of leaks or mildew or mold. Your inspector and your termite company will also be looking at that. Formaldehyde. Formaldehyde is a substance known to the state of California to cause cancer. If it's built prior to 1978, it will be on the Residential Environmental Hazard Guide for homeowners and home buyers. That is a report that you need to download. We used to have books, but now it's just a download that you need to give to the buyer. Geological hazards, that also will be on your NHD report. And also if it's built prior to 1976, then it will be, 1978, it will be an earthquake report will need to be given, and an earthquake booklet will need to be given. Inspections. Buyer and seller are advised that the buyer has the right to obtain various inspections of the property. Most residential purchase agreements have that. So that would be the pool, the spa, the septic, the well, the roof, foundation, anything that has to do with the mechanics of the property. You also want to investigate mold. A lot of times mold is brought to your attention by a termite company or by the inspection company. You also want to investigate any kind of issues with windows. If you see new windows or solar or artificial grass, you want to make sure that there's no additional liens on the property that could be on the tax report or the tax rolls. You always want to make sure you do the homework on that. Pets and animals. Buyer and seller are advised that a current or previous owner has had domestic pets or animals on the properties. Anytime you have a smell in the house, or anytime you have something you can't figure out, you need to write that on your Avid, which we will get to soon. But that is something that you would do as your physical inspection, is to be the eyes, ears, and nose of that property. Septic systems. If there's a septic system, you want to make sure that it's certified and that it is working properly. Soil and geological conditions. If you're selling something on a hillside, if there's any kind of drainage or grading issues, you want to make sure that you are doing a geological inspection and or a soils inspection. Square footage, lot size, boundaries, and surveys. A lot of times your appraisal will be taking care of that. Water intrusion, that's something that your inspector will look for, but that's something you also have to look for. If you see any evidence of water intrusion, any spots, or any kind of indication of leaks, you need to make sure that you are disclosing that on your visual inspection. Wells and water, again, you will hire a third-party company to do that. Pest control will take care of wood destroying pests. Accessory dwelling units. Accessory dwelling units are called ADUs, and they could be a granny flat, an in-law unit, a backyard cottage, a secondary unit, anything to do with that. That will be on your city reports. And we typically just do a visual inspection and do a separate Avid for that. An Avid is an agent visual inspection disclosure, which we will be going over tomorrow. Building permits, zoning, and code compliance. That will also be on your city report. Buyer intended future use and modifications to the property. If you are selling a piece of property that is more rural or is near a vacant lot, you want to look at the general plan of the city and make sure that your buyer has done that to see what could be built on that lot and or what could take over the view of that lot. That is part of the buyer's investigation, and you just need to tell them where to go to get that information. California Fair Plan. California Fair Plan is an insurance policy that if the buyer cannot obtain insurance, that the California Fair Plan will be available to them to insure the property so that they can still purchase. Future repairs, replacements, and remodels. If you see indication that there has been a remodel on any portion of the property, that should send a red flag to you that you need to make sure you're looking for permits. Heating and ventilation and air conditioning systems, your inspector will be looking at that and making sure that it is in working order and in to concurrent code. Historical designation, Coastal Commission, architectural, landscape, architectural, or open space, and any other restrictions on the building or improvements. This is a big one. If you're selling something at the beach, you might be concerned by sea level rising. Our global warming is causing our oceans to rise in sea level, and it could mean that that property could be underwater at some point. You need to make sure you disclose something like that. If it's in a historical district, you will need to disclose that so that the buyer is aware of what he can and cannot do to the property. And if it's in any other areas close to agricultural, you will want to do the agricultural disclosure that states that there could be pesticides being used and around that property. Insurance, title insurance, and title insurance after foreclosure. Depending upon what the history is of that property, you want to make sure that your title company is doing a full title search on it and make sure that there's no provisions that are being excluded from that report. So you want to make sure that you're reading your title report. You want to make sure that your buyer is reading the title report. If your buyer does not understand the report, they need to call the title officer at the title company and get their questions answered. It's very, very important. Land lease. Buyer and seller are advised that certain developments are built on land, leased land. We have a couple areas in our county that are on leased land, and usually the lease is for 50 years. But also when you find a property that's on leased land, it's very difficult to get financing because that lease expires and typically the lender does not want to loan on something that could expire. So you'd have to do the research on that to make sure that the lease is at least 30 years or longer, or if it's being renewed by jurisdiction. Marijuana, cannabis, methamphetamine labs, the seller needs to disclose any and all of that. There's risk to people that are very sensitive to that, so you want to make sure that you are disclosing all of that information. Owner, titles, insurance, you need to make sure that the truth in lending and RESPA disclosures have been given to the buyer. That requires the lenders must tell the borrowers that title insurance is optional, that they don't have to have it, but it's encouraged. Most lenders will not lend unless there's a title policy on the property. Unless you pay cash, you don't have to have a title policy if you pay cash. However, I would not recommend it. They just need to know that it's optional. Rent eviction control laws and ordinances. You need to make sure that that is being disclosed, that they know if they have a property where a tenant is involved, that they know the rules and regulations, and especially right now with COVID, I would recommend that you call a property management company to find out what those rent and eviction control laws are. Retrofit building requirements and point of sale requirements. In our area, we only have smoke detectors, carbon monoxide detectors, and our water heaters need to be strapped. In other areas, there are gas shutoff valves, there's tempered glass that needs to be repaired if it's not. So you just need to make sure that on your city report that it says what the requirements are, and make sure that that has been disclosed to the buyer. Short-term rentals and restrictions. Those rules are changing, seems like monthly, especially right now with COVID. Short-term rentals, some cities have restrictions where you cannot do a short-term rental. Like Carpinteria has a restriction that they will not allow short-term rentals. They have to be at least 5 days. There's a lot of taxes and a lot of rules that a buyer or seller has to adhere to. You just want to make sure that they are following those rules and that they know what those rules are. Views. Buyer and seller are advised that present views from the property may be affected by future development. If you are selling a property on a hillside or in a canyon where the views is a reason they're buying the property, you may want to make sure that you are disclosing that that may not stay that way forever. And they need to investigate that themselves, not by you. Swimming pool and security and safety. Buyer and sellers are advised that the state and local laws may require installation of barriers, anti-entrapment grates, access alarms, self-latching mechanism, pool covers, exit alarms, and various fire safety and measures concerning features of the property. If you see a pool in the backyard, you need to make sure that you disclose to that buyer and or seller that there needs to be a separate insurance policy on a pool always. It's not automatically covered in your property insurance. And you need to make sure that there's barriers around the pool and that it's all to code. So you would call a pool company to make sure of that and find out what the rules are and the laws are for that pool. And make sure that all of that is being disclosed. Water shortages and conservation. We have a voluntary water shortage here where we don't have anything mandatory, but we do have a voluntary. We are still in phase 4 of our water shortage because of our drought. That all needs to be disclosed, and a lot of times that will be on the city report. The 1915 Improvement Bond and Melrose Community District. If you are selling a piece of property that has Melrose, it will be on the tax bill, and you need to make sure that the buyer is aware of how much the Melrose is and how often it is charged, and whether it stays with the property or whether it can be transferred at the time of sale. Bonds are a little different than Melrose. A bond usually stays with the property for the life of the property. We have several areas in our community where we do have Melrose. River Park is one of them, and there are 5 Melrose there. So you just want to make sure that if you are looking at a new development, that you make sure that the Melrose is either there or not, so you disclose that. Off-site and neighborhood conditions. This is a golf course disclosure. If you are selling a property near a golf course, there's all kinds of things to disclose about that, especially maintenance and golf balls that may be hit your property and the noise that a golf course provides.
Karen, hold on one second.
We have a couple questions in the chat. Hold on one sec. How would you know if there was a death on the property? You have to ask that seller or some way to know through title or some other way. We're relying on that seller to tell you whether there's a death on the property or not. Sometimes you can check the obituaries to find out if there's a death at that property, but it has to be within the last 3 years for the seller to have to disclose that unless it's been a violent crime. Andy, it says, where are these areas? What was your question regarding to?
That was pertaining to the land lease.
Oh, to the land lease. So in Ojai, right before you get to Miners Oaks, if you go off to the left, there is a road that takes you to development back there that is on leased land. And that's one of the ones that I know of that is in our community. Okay. Neighborhood noise sources. If there is noise that happens on a regular basis, whether it's a plane, if you're in a fly zone, or whether it's a freeway that you can hear from the outside, if there's a stop sign where everybody screeches their brakes when they stop at the stop sign, if there's a school bus where kids are screaming and yelling and having a great time getting on the school bus, that would be a neighborhood noise source, and you would have to disclose that. If there's a barking dog, that happens all the time. So that's why I recommend people to go by there and just check to see if there's any barking dogs, see if there's somebody playing a trumpet. It can be just as simple as that. You want to make sure that you entice your sellers to encourage you to tell you what those noise sources are. Schools, very important. How many times do you have people buy a property because of the boundaries for a school? School boundaries change depending upon the money that the school needs. I have seen boundaries change several different times, so we need to make sure that the seller is disclosing what the schools are in that district, and then the buyer needs to look online to make sure that that school district is where they want to be. Underground pipelines and utilities, that will be on your NHD report. A lot of times if there's underground pipelines under a piece of property, there'll be an additional map on the NHD report that will show you where those underground pipelines are. A lot of times they are down a ravine or a barranca in our area, and your NHD report will show that. Death on a property. It protects the seller from failing to disclose a death on the property that occurred more than 3 years before the buyer has made the offer on the property. Failing to disclose if an occupant of a property was affiliated with HIV or AIDS, regardless whether the death occurred or if so, when. The law does not protect a seller from making the misrepresentation in response to direct inquiry. So if there's been a death on the property and the seller for some reason does not tell you, and the neighbors come and tell you, when we were able to do open houses, that would be the first thing out of the mouth of a neighbor. Did you know so-and-so died here? Did you know that there's a sex offender here? Did you know anything about the property? They'll be the first people to tell you. Once they tell you, you must tell everyone. So if you know, you must disclose. Earthquake fault zones and seismic hazard zones, those will be on your NHD report, and they will get a copy of that. EPA lead-based paint renovation, repair, and painting rule. If the property is built prior to 1978, most likely it has lead-based paint, and there's a separate disclosure for that in our disclosures that must be signed by all parties, because if there's lead-based paint and it needs to be renovated, there is a specific way that that has to be renovated, especially if it's near a school. It can't be just repainted and painted over. It has to actually be removed and be removed with risk there. Fire hazards, that will be on your NHD report. Fripta, California withholding. So Governor Schwarzenegger, years ago when he's the governor of our state, he put this in place. So Cal Fripta is basically if the buyer owes any California tax and does not disclose that to this, if the seller owes California tax and does not disclose that to the buyer could become liable for that tax. And so escrow in our area takes care of the Cal Fripta, which is wonderful because it takes the liability and responsibility off of us, but it does have to be disclosed, and it is a form that escrow will give to the buyer from the seller during the course of escrow. Flood hazards will be on your NHD report. Megan's Law. Megan's Law is a website that will disclose any sex offender within a square mile of the property. Now, don't go look at the Megan's Law disclosure website, because if you know there's a sex offender somewhere, then you have to disclose that. Have your buyer go look at the website, make sure that they're comfortable. There are several different levels of sex offenders. So make sure that your buyer understands that as well. If they have questions, they can go to the website or they can call the police department to answer any questions that they may have about that. But that is a right that they have during their investigation period. Notice of your supplemental tax bill. In our county, we are about 6 months behind in getting those supplemental bills out. Once the property has closed and the property has been reassessed, the buyer will get a supplemental tax bill that will bring them up to speed on their property tax. I promise you, you'll be the first person to get that phone call, and you'll just have to refer them to the assessor's office.
But it's good to let the buyers know that to be expecting this, because a lot of buyers, especially first-time home buyers, they are completely unaware of a supplemental tax bill. So because of the 14 pages in the SBA, and these are all definitions from the contract basically, and this particular point is reiterated within escrow instructions, it still comes as a shock. So it can be from, and the supplemental tax bill is the difference between the purchase price and the new assessed price. So it's depending on where they're at on that, it can be, 1,000 to double digits. I had a client who received a bill that was $20,000. So just make sure that all parties are aware.
Absolutely. And the seller usually will get that supplemental tax bill prior to close of escrow, but in our county, we're so far behind, you don't get it until 3 or 4 months after the close of escrow. So you just need to make sure that you let them know that they will be getting one, because you usually are the first person to get that phone call.
You will be the first person you get that phone call. You will
Quick
be.
question on that. Do they not collect the difference between the purchase price, versus when the sellers, when they first bought theirs? Don't they collect those taxes up front at escrow?
They do collect the taxes up front, but it's still not going to be enough to catch them up. So it depends on what time of year that the property is purchased as to how much money they collect in escrow for taxes. And especially if they have an impound account, they may not have enough in that impound account when the supplemental tax bill comes. So you just need to make them aware that one is coming.
So if you have a closing in July, you remember the acronyms for your taxes, no darn fooling around, right? So they're due in November, late in December, due in February, late in April. So if you have a closing in July, you will get a supplemental tax bill
You will.
before the end of that year. So escrow is really good about collecting the prorated taxes up until the close of escrow date.
Absolutely.
Oh, got it. Okay.
Okay, so zone maps may change. So zone maps for earthquake faults, seismic hazard areas, high fire hazard areas, special flood hazard areas, potential flooding areas. All of those can change at any time. I would say in the last 5 years, they've changed like 4 times. And so someone who doesn't need flood insurance now may need flood insurance when they change the flood zones.
And they're changing now.
They're in the process of changing now. So we will get new fire hazard area maps, but the third party company, which is your NHD, will be the ones to give you the information on those flood maps. And a lot of times they do change 3 or 4 times in the last 5 years. So.
And it could work up to the benefit. Maybe they're currently in a flood zone, and then with the change, they're now out of the flood zone.
Correct.
So that's, I know for Seymour Park, they're currently working on rezoning.
They're doing it in Ventura County as well.
Mm-hmm.
Yes. So it is 10 o'clock. I think we'll take a 10-minute break and get up and stretch. And we'll see you guys back here at 10 after 10.
Hang on one sec. Let's share my screen. Hold on. Sorry, guys. Okay.
All right. So contracts related issues and terms. Arbitration. We've gone over arbitration. It just reiterates it again. Electronic signatures. It basically says that we have the ability to use electronic signatures. Escrow funds. Buyer and seller advise that California Insurance Code provides that escrow companies cannot disperse funds unless they are significant good funds to cover the disbursement. So anytime, sorry, there was all kinds of notices coming up on my phone, on my screen. Anytime there are good funds put into escrow, they have to go through the Good Funds Act to make sure that they're good funds and escrow can hold those funds, especially if there's an out-of-state check or if there's a cashier's check that needs to be used for the deposit. Those all will be wait until they have good funds. Home warranty. Buyer and seller advise that they can purchase a home warranty plan covering certain standard systems. In our deposit receipts, when we write them, we want to make sure that we put a CRUS plan in place so that it covers our seller and covers us if there's any dispute in the transaction. Identification of natural persons behind shell companies in all cash transactions. There's just rules with the Treasury Department regarding all cash transactions and how they have to be certified. And that is something escrow does for us in our area. Liquidated damages, we've covered that already. Mediation, we have covered already. Non-confidential of offers. Buyer is advised that seller or listing agent may disclose the existence, terms, conditions of buyer's offer. If you have it in writing that the seller will allow you to discuss the price and terms of any other offers in a multiple offer situation, it makes the seller typically get higher and best price at that point. Online wire funds transfers. Instructions for online or wire transfers to escrow deposits have been known to be intercepted by hackers. That is the wire fraud that we had talked about and the disclosure that we had gone over already. Other facts affecting the property, community enhancement and private transfer fees. We've gone over that already. A lot of this is redundancy. It's just making sure to reiterate it to the buyer and seller to make sure they're checking everything. General recall and defective products. There's a list online for all the products that have been recalled. And typically what gets recalled is like a water heater. It could be a fire sprinkler system. I've had that be recalled. You just need to have your buyers go on that Consumer Protection Safety Commission website and check to see if there's anything in the property that they're concerned about that could have been recalled, so that they know that ahead of time. A lot of times sellers do not know what's been recalled and what's not been recalled, especially when it comes to roof tiles and things like that. So
any licensed property inspector will know, ranging from electrical panels to every single thing that you just talked about.
Exactly. And they usually put that in their inspection report also. So it's reiterated several different times. Homeowners associations, covenants, conditions, and restrictions, which are CC and Rs, need to make sure if it's in a condominium complex or anything that has CC and Rs, that you get the rules and regulations and all of the paperwork that goes along with an HOA. And single family homes can have an HOA also, so make sure that you are aware of that. Like Stonehenge in Ventura has an HOA because they have a little park to the side of that development, and the HOA covers that park. Legal action. Buyer and seller are advised if the seller or previous owner was involved in legal action affecting the property, that the buyer should obtain and review public and other available recordings to determine that legal action. A lot of times that will be on your termite or on your title report. So you can also check the county website to make sure that there's no legal action against a property. It also will be, if there's any violations to the property, it will be on your city report. Marketing, internet advertising, internet blogs, and social media. It specifically states that we do all of those things as brokers, and it's just acknowledging the fact that they have been disclosed, that exist, that we put our stuff on social media. PACE loans and liens. This has to do with anything that is energy efficient. So windows, it could be solar panels, it can be artificial grass, it can be roof tiles, it can be anything that makes the house more energy efficient. And PACE loans and HERO loans are the type of loans that you get for those kinds of improvements. The problem is the seller doesn't always disclose that to you. It's usually on your title report or on your tax bill, your property tax bill. I had a situation on one of my properties that it was not disclosed to us until the mid part of the escrow after the title report came back. And there was a $40,000 solar system that was installed in the property, and the seller hadn't made any payments at all, had completely forgotten about it, and didn't tell us. And we had to negotiate that because the buyer didn't qualify for that extra $40,000. And so that caused a huge problem. So make sure that you're asking the questions to the seller as to whether there's any kind of improvement like that, and whether there's a lien on the property for anything like that. Rekeying, I recommend that you rekey. It's always recommended by everyone to rekey, including garage door openers and remotes, to be recoded. A lot of time the home warranty company will have that in their plan so that it can be rekeyed. Solar panel leases. So it's different if the solar panels are leased versus purchased and on the tax rolls. If the solar panel is leased and the seller does not own the solar panels, then there's a whole process for that to make sure that the new buyer can qualify for the lease and that the seller can transfer the lease. So make sure that if you see any kind of the home improvements that you ask the questions about that. So that takes care of this disclosure.
What about recording devices? Number 9, before we move on.
Oh, I'm sorry, recording devices,
Yeah.
yes. So audio and video recording devices both must be present on the property whether or not notice of such devices have been posted. You always want to make sure that you put a note on the door saying that there's recording devices. Nothing is worse than having people come into the property and say things that are not nice about a property. You always want to notify people that there's recording devices.
Yeah, say not nice things and then go write an offer on it.
Exactly.
And then have their offer rejected. So,
Exactly. I've had that happen.
oh dear.
All right, let's make sure there's no questions. Perfect. All right, moving on. Contingencies for sale of buyer's property, a COP. So if there's a property that needs to be sold when you're writing an offer on a property, so the buyer's property needs to be sold before they can purchase the one they're writing the offer on. This COP form must be included in your transaction and must be included when you present the offer. So depending upon what's going on with that property, sometimes it's not even listed, and hopefully you would be the one to get the listing and start marketing that property and give all the details. So this is the form you use if you have a property that needs to be sold prior to close of escrow and before the buyer can qualify for the property that you're writing on. And it could be that the buyer just happened to see this property come up. They weren't planning on moving, but now that that property is up, they want to start moving, and then you've got a new listing as well. A couple of things I want to bring to your attention on this particular form. When you have a piece of property that needs to be sold and hasn't sold yet, you need to make sure that the buyer understands that the seller can continue to list the property, continue to offer his property for sale, even if he accepts the offer from that buyer. And the buyer just needs to know that, because sometimes the buyer thinks, oh, the seller's going to sell it to me and nobody else. No, that's not true. They're looking for the highest and best price that they can possibly get for that property, whether they sell their property or not. Once the seller has accepted an offer on the property, they have to notify the buyer in writing and let them know that they have a certain amount of time to perform to get that property sold or remove that contingency of the sale of that property. So all of those things are on this contingency of buyer's property. All of those explanations are on this form. It just depends on what the situation is with that property. Okay, seller counteroffer number 1. Anytime you have a purchase agreement and they don't accept it as you have written it, you're most likely going to get a counteroffer. And the counteroffer will have just the terms that the seller does not agree upon. And most of the time it's the price. Sometimes it's some of the terms, but all of those items will be on other terms, and usually it's listed numerically. So you'd say number 1, sales price to be $500,000. Number 2, close of escrow to be March 1st, as an example. And then you just put an expiration of the counteroffer down on number 2 where it says expiration of the counteroffer. You just need to put a date and time. Usually it's 24 hours. In this market, it may be upon presentation if you have the opportunity to give that to the seller. And then once the offer and counteroffer have been accepted, it gets acknowledged. So this particular form is to be used when there is only one offer on the property. The next form is the seller multiple counter offer, and that is when there is more than one offer on the table and the seller is countering all of those offers. And you use the same thing. So multiple counter offer number one, and you do a separate counter offer for each one. Each one of those offers would get its own multiple counter offer. You would list the terms that the seller did not agree upon, and then put a time frame down where expiration. And then number 6 is acceptance of seller's multiple counter offer. And once the seller accepts that, it must be acknowledged by the buyer. And the buyer's agent usually is the one who does that. I was trying to think if there's anything else I wanted to say about that.
Are there any questions like regarding how to fill out the COP, the buyer COP or anything like that? I feel like we didn't cover that in depth.
You can put any situation on that COP that the buyer is having on their property. And it's pretty self-explanatory. That's why I didn't go into such detail. But same with the counter offers and the multiple counter offers. It's depending upon circumstance. But the most important thing is on a multiple counter offer that the seller gets to choose any offer that they choose once they get all of the multiple counter offers back. So you only can sell the property to one person. Buyer counter offer number 1. Same situation if you get, so the buyer has written the offer, the seller has countered the offer, and now the buyer is going to counter the counter. And same situation, it would be everything that the buyer did not agree upon with the seller's counter. It could be the price, and sometimes the price goes back and forth. I think the most times I've ever gone back and forth on counteroffers is 11 times.
Oh gosh.
Yes, which is terrible.
That's horrible.
Just so you know, 11 times is not the normal. 2 or 3 times is usually normal.
Yeah, I don't think you should go above 4. Otherwise, you need
Yeah.
just to start new and write a new contract. Honestly.
Absolutely. It gets really, really diluted, if you will. But you always want to make a counteroffer and back and forth until you have an accepted offer. And like Chris says, if you get past 4 or 5 counteroffers, you may just want to rewrite the offer completely based on all the terms that's been negotiated back and forth.
Yeah.
And then you want to keep those counteroffers in your file until the transaction is closed. Okay. Now we're to Century 21 Everest forms. This is the addendum to the real estate purchase contract. And basically, I'm going to go over a lot of these things because there's things you need to know about them. So escrow process complexity. It basically says the escrow is not easy. Everybody has a date and everybody tries to adhere to the contract. But honestly, it is complex. It can be very taunting to people. And so you just have to be a little flexible to make sure that everybody is adhering to the contract and that you can get the property closed. Protect your money, wire fraud advisory. Again, it is reiterated and they have you sign it so that you've signed it 3 times by now for wire fraud. So just make sure that you're reiterating it every time they have money in their hand or are going to receive money. You want to reiterate it again, just to make sure that they understand wire fraud. Purchase or sale by one spouse. If one spouse is purchasing or selling separate property and his or his sole and separate property, the other spouse shall sign appropriate documentation consistent with the property spouse's agreement within 10 calendar days. So let's say that it's a property that is the sole and separate property as a married man. So he's married, but he bought the property on his own. The title shows that it's his sole and separate property. The wife, because we are community property state, the wife will have to release her interest in the property in escrow. And there's a documentation for that, and escrow will take care of that. But that's the example, because he can sell the property by himself, but in a community property state, she still has the right to part of the value of that property. Value. Buyer and seller acknowledge and agree that while brokers provide information regarding comparable properties to the subject property, the value of the property is subjective. The broker cannot guarantee the current market value of the subject property. So that's why we have you run comps. And when you run comps, we have the buyer sign those comps or the seller sign those comps. And that is part of what needs to be in your file. Information from the lender. Listing agent is authorized to contact buyer's lender and loan broker directly regarding the process of the loan application. Seller's agent will provide the listing agent with the name and contact information for the loan broker. So when you receive an offer on a property and you're the listing agent, you want to make sure that that buyer has been approved and that qualified, that letter of qualification is actually legitimate and not just written on any piece of paper. You need to make sure that that lender actually knows who the buyer is and make sure that the lender is actually processing that loan. There's a question in the chat.
Yeah, I just noticed that. Sorry, Kelly. What happens to the contracts, documentation, counteroffer agreements if you write a totally new offer? Do they become moot as per the new agreement or remain part of the file?
They actually become moot at the end of the day because you're rewriting the contract. But if you are going back and forth on counteroffers, you always want to keep proof of what happened until that property closes, and then you can sort out the file.
So I think it's important whenever you're working any type of file, always keep written notes, print out your text messages, you know, any type of communication, any emails, because that's just your record of proof for anything.
Absolutely. Digital processing and storage fee. Century 21 Everest charges their client a $395 fee. The fee covers services including but not limited to a full review, collation, indexing, and digitizing of the transaction, storage of the transaction documents after the close of escrow, supplying with you electronic copies of your collated index transactional documents for a PDF. So this is where once this form is signed, this goes to escrow, and that's how your escrow company will charge whoever you are working for, whether it be the seller or the buyer, the fee of $395. If you, in our office, if you don't charge the $395 to your buyer or seller, then you are to pay that fee. Photography and internet advertising. Seller understands that the broker may photograph or otherwise electronically capture images of the exterior and interior of the property. That's just basically a disclosure that says they are allowing you to do that by initialing the bottom of this page. Mandatory government retrofit, we've already covered that. It's reiterated again. Same with homeowners associations. Same with earthquake disclosure. Now here's a different one. Water reservoir improvement. The property may be serviced or served by a located near an area which water reservoirs or dams are located. For instance, the Matilaha Dam. Matilaha Dam in our area is horrible. It's ready to explode at any minute. I mean, it could just happen. It's been a disclosure since I've been in real estate, and they have been fixing it since I've been in real estate, which has been 31 years. So that's why it's on a disclosure. So if you were selling anything off the avenue or up in Ojai anywhere in that area, you'll want to put a little highlight next to number 12 and make sure that they understand that. It may not affect that property directly, but it will affect the area. Metrolink and railway, just be advised whether there is one around that property or not. Boeing, Rocketdyne, and Santa Susana facility. This applies to people in the Santa Susana Simi Valley area, but because we service that area, it's on this disclosure. RV parking enforcement. There are plenty of areas in the city of Thousand Oaks and the city of Ventura that do not allow RV parking on the street. And that's what you're acknowledging. The city of Thousand Oaks records search and report of city inspection reports. It basically says that if the property is situated within the city of Thousand Oaks, the transaction must include a city report of the residential building records. That is true for the city of Ventura. So that's just a disclosure. You want to make sure if the property is in any of those cities that you have that in your file. The city of Ventura sewer lateral ordinance, it's basically disclosing that to make sure that you have done a scope and that you file that with the city of Ventura, and it gets filed through the water department, not through the city of Ventura. Ojai Sanitation District as of December 1st, 2015. It's also got a mandate that the sewer lateral line be inspected. The difference is that they want their employee to be standing over the plumber to make sure that he does his job properly. That's the difference between Ojai and any other city. High winds disclosure, it basically says that be advised that the located between Ventura and Los Angeles County, we experience high winds. Oak tree ordinance, the city of Ojai and Thousand Oaks, you must have a permit to touch an oak tree. So you can't cut it down, you can't trim it, you can't do anything without a proper landscaper that is allowed to do that, and you have to have a permit. Ordinance involving water conservation, impact hazard, glazing, and gas shut-off valves. In the city of Los Angeles, they require gas shut-off valves for earthquakes. You just need to know that if you sell a property down there. County jail facilities. This basically states that Los Angeles has a jail facility. Pitches Detention Center is situated in the east side of the I-5 freeway near Castaic. The county jail includes 4 jail facilities ranging from medium to maximum security. In the county of Ventura, we also have a jail. It's not on this form, but if you sell a property anywhere around the government center, you must disclose that there is a jail there in case someone escapes from that jail. Bermite disclosure. Buyer and seller are advised that mostly vacant properties, approximately 1,000 acres located in the general vicinity of South Soledad Canyon and Bequia Canyon Road, contains contaminants from past manufacturing operations. Saltwater Pools, Santa Clarita Valley Sanitation District adopted an ordinance making it illegal for both new and existing saltwater pools to be connected to the water sewer system. So that's just another disclosure that you need to make sure if you're selling a property in those areas that you disclose about saltwater pools. My understanding is Ventura is working on that, so it's coming. Sand and gravel mined operation proposal. Buyer and seller are advised that Los Angeles County Planning Commission has approved a proposal to expand the sand and gravel mining operation in Soledad Canyon. So it's between Fillmore and Santa Clarita is where that is. Water softeners. The installation of residential self-regenerating water softeners is prohibited in Santa Clarita Valley. It will be true in Ventura County soon. They are working on that as well. Water softeners are bad for our water system. We have a question. Can a
Yes.
saltwater pool be turned into a normal pool? I don't know the answer to that. That would be something you would have to investigate through a pool company or through a pool designer. Someone who installs pools would know that. So the point of all of these disclosures that we've just gone over, especially with the statewide advisory, is that you want to make sure you're pointing people in the right direction to get the answers that they need in order to be sure that they get the answers they need and that they're comfortable with those answers. We still have one more, Chris.
Yeah, no, I noticed. Sorry, guys. I had sent everybody, I scanned it upside down, so you all had a blank sheet. I'm so sorry about that.
Oh,
So the affiliated business arrangement.
okay. So I didn't get that one either, just to let you know.
I'm so sorry.
So the affiliated business arrangement disclosure for Century 21 Everest simply says that all the companies that we own, which is Seller's Choice, NHD, Inspiro Financial, Mobile Notary, and All Valley Escrow, when you own more than one company, you do have to disclose if you are making money off of those companies. And it's just a disclosure that simply says that. So you just need your sellers and buyers to sign that form.
It's more of an acknowledgement. So, I mean, especially if you're sellers, they definitely have a choice.
Exactly.
We would love them to use our affiliates, but they do have a choice.
Exactly. So out of all of these disclosures that we have done today, the agent visual inspection disclosure is probably the most important piece of paper that you fill out as an agent, and then everybody signs as a disclosure. So an agent visual inspection is simply that. You are required to go wall to wall to wall in the property that you are selling and notice anything that is wrong. So it's your disclosure that says, I see a stain on the ceiling, or there's a stain on the carpet. And they have specifics that you need to do for that. So it's a visual inspection. You do not have to open up cabinets or closets or anything like that in order to inspect them, but you do need to make sure that you do a thorough job in inspecting that property. So your inspector inspects the property, your buyer and seller are disclosing everything they know about the property, and this is your obligation to the buyer and or seller to disclose everything that you know about the property. So on page 2, it states at the top if it's a triplex, duplex, or fourplex. If it is, you must do 2, 3, or 4 of these forms, one for each unit. You want to state the company name, so Century 21 Everest. You want to state the inspection date and time that you were there. You want to state the weather conditions. It was sunny, it was raining, it was beautiful outside, 70 degrees, whatever you want to put to give whoever reads this form the visual of what you see and heard and smelled while you were there. You need to say who was there, whether it be the inspector, maybe you do it at the same time that the inspection's happening. The buyer might have been there, the seller might have been there. Maybe it was buyer's family. Anybody that was there during the inspection of the visual inspection that you're doing, you need to write the names of those people that are there so that looking at this form, they will get the picture of what happened. So when you first walked into the property, what do you see? Maybe you see tile floors in the entry, and maybe the entry is just a square. Like if you're doing a condo, it could be a square of linoleum, and then you go straight upstairs. So you just want to disclose what you see. In the living room, maybe it's carpet, and maybe there's a stain on the ceiling, maybe there's a broken window, maybe there's blinds that are a little tweaked that don't look right. You're going to write down every single one of those things. Same with the dining room. When you walk through the dining room, you're going to see probably a sliding glass door. Maybe the sliding glass door has a little crack in the window at the bottom. You want to acknowledge that. Maybe it's painted different colors. You want to acknowledge that. In the kitchen, you're going to look at all of the appliances. You're not going to turn them on. You're not going to run the water. You're not going to open the cabinets. You're clearly just going to look at it visually and write down what you see. Maybe it has granite countertops. Maybe it has corrosion around the faucet on the sink.
I also, for the dining room and kitchen, like for light fixtures, because sometimes those are excluded items. So I'll put, you know, dining room chandelier or crystal chandelier or something like that. So in the kitchen, recessed lighting, or maybe it's fluorescent lighting or that has water stains around it from the roof. So you just want to just write anything that you visually see without actually doing an inspector's job. So just be thorough about that. And if there's nothing to report, then you say nothing to report.
Or you say nothing noted.
Nothing noted. Scuffs on the walls. I showed one home where they let the kids play hockey practice in the house. So there were, you know, puck stains everywhere. And I had no idea. I thought they were black markers, but my client was an ex-hockey player and he's the one who explained it to me. I'm like, who in their right mind is going to let someone do that? But that's what you do need to write.
It could be a burn on the countertop from a curling iron. It can be anything that you see when you walk through the property.
I will say the important thing, Karen, you can correct me if I'm wrong, but I always, on my Avids, every single room, I will notate where the smoke detectors are. If it's in the hallway, upstairs, in the bedrooms, because that can become an appraisal issue, especially if the appraiser is not thorough and says that a smoke detector or a carbon monoxide detector is missing, and you know for a fact that you saw it, you know, on your Avid. So that's helped me a lot.
There's a question. Are you listing both good and bad things? Granite countertops, only listing things that are wrong with the granite tops. Only things that are wrong.
Wrong.
Only things that are wrong.
So if it has a crack, notate that it has a crack. If a vanity has a stain, notate that it has a stain. However, if you're in the bathroom and you see what you may think is mold around the bathroom or shower tile, do not state mold. State discoloration, because you're not a mold expert. Sorry,
No,
Karen.
No worries. So this, I just got to reiterate that this form is like the transfer disclosure statement. It goes to court when you go to court. So you want to make sure that you are absolutely disclosing everything that you see. So the other room could be a laundry room. It could be a workshop. It can be a separate sewing room that's not in a bedroom. So your other room is anything that is extra that isn't spelled out on this form. Hall and stairs, including common areas. Typically, The hallway is a way to get to bedrooms and bathrooms within the house. And a lot of times that's your most high traffic area. So your carpet's going to be worn. Your linoleum may be peeling. Those are the kinds of things that I look for in a hallway. The other thing that you look for is when you look up, you might see attic access in that hallway. And you want to note that. Bedrooms, there's room for 3 bedrooms and there's room for 3 bathrooms. If you have more than that, then you can put the information on the other room for the additional bedroom or bathroom. So in the bathroom, like Chris says, you want to make sure that you are not disclosing that it's mold if you see something black, because it may not be mold. It just may be slime or whatever. It may be something other than mold. So you just want to make sure that you're not elaborating on the fact of something that you don't know for sure. The next page, it says, if the property is a duplex, again, you do more than one form. It gives you other room, other. So in those other spots, if you notice, it says below that you're looking exterior building and the yard, front, back, and side, and the garage parking area excluded in the common areas. So your other is maybe fences. It could be a railroad track behind the property. It can be anything that needs to be brought to the attention, whether it's a smell, whether it's something that, I'll make stuff up at this point. Maybe there's a building behind the property that is a commercial building, you'll want to disclose that. If there's a freeway noise that you can hear from outside, but you can't hear it on the inside, you'll want to disclose from standing outside in the backyard, I can hear the freeway noise. And a lot of our areas have that. You would also put there that it backs to a field and the possibility exists that pesticides are being used. Let me think of other places. It could be backed up to a grocery store or a complex. It can be backed up to a restaurant. Anything that is out of the ordinary. If it backs to a school, or if you can hear the bells ringing from a school, you need to disclose that. So anything that you hear, anything that you see, and anything that you smell, you want to put on the form. If the house is so cluttered that you can't see, you need to say that the house is so cluttered I can't see. For instance, the countertops. There's so many things on the countertops, I can't see the counter, so therefore I cannot give you a visual. So you just
The
need
garage, yeah.
or in the garage. You know, if I always tell people to move everything away from the walls so that the termite company can do their job. Right. If they can't do that, then you need to say that it's obstructed and you can't look at the walls, wall to wall to wall. If there's anything unusual where you can't park something outside of the garage, if there's RV parking and there's some rule about that, then you need to disclose everything you know about it. Then everybody has to sign it. The buyer, the seller, both agents, and the other agent that you're working with on the other side also needs to do an agent visual inspection, and everybody in the transaction needs to sign that one as well. So there's always going to be 2 unless you represent both sides, and then you need to even be more diligent about your avid. So that concludes our contracts class for today. We actually have 10 minutes left, which is awesome. So if you have any other questions, I'm happy to answer any of them for you. And I hope you learned a little bit about all of the disclosures that you need to do for a transaction when you sell a property.
Does anyone have any questions?
Many of these things, I mean, it's kind of miraculous that a transaction's ever closed. I mean, looking at this, you know what I mean?
I
It's like,
know.
A lot of things that need to happen on a transaction.
so couple things, like when are these things being delivered? And like, how do you know? I mean, I know we have office manager, you know, people checking agreements and contracts and everything, but like, when do people get in trouble, or how do you really know that you're going to stay out of court or whatever?
Well, number one, it's my job to keep you out of court, but I will, I will say that you need to do your AVID, your agent visual inspection, right after your contract is accepted. So right at when you're starting your inspection periods and everybody is doing their due diligence, that's when you need to do yours as well, because you need to deliver that within that 17-day period. Is that your question?
Yeah, sort of. I mean, we've been through a bunch of different disclosures and things, you know, so if I were buying and you presented me with 87 pages of disclosures, I would find that rather daunting. And I might just decide this is just too damn much work and effort and stress. You know, so how are you timing that stuff so that that doesn't happen? And then, yeah, just, you know, just the process of, I mean, is there a checklist somewhere that I need this, you know what I mean? All
Yes,
383 things that I need to finally get this deal done.
Yes, there is a checklist, number one. Number two, when I'm working with a buyer and I'm writing an offer for a buyer, I will sit and write the offer. I will explain the first set of forms that we did yesterday to them and have them sign all of those at one time. So that's all part of the offer, and I present that to them. When I present the offer to the agent, I'm going to give them the agency, I'm going to give them the contract, and probably the wire fraud advisory and comps. That's what I'm going to give to the listing agent to present the offer. I'm going to hold everything else in my file because it's required for my file. Okay. Once I have an accepted offer, we're going to open escrow. Once we open escrow, then we start our investigation. So the buyer needs to sit with the lender right away and make sure that the lender has everything they need to order the appraisal, so that that gets ordered. It takes about a week and a half right now to get an appraisal done. So you need to get that ordered right away. The next thing we order is the inspection. So we want to make sure that the property is in good working order and that the buyer is accepting the property in its current as-is condition, right? When we do the inspection, I bring the rest of those disclosures. And after the inspection is done and the buyer has paid the inspector, then we usually go and sign the disclosures that I have brought, and I explain all of those disclosures before we get the escrow instructions, because you want to do a signing party when you write the offer, then you want to do a signing party when they do the inspection, then you want to do a signing party when you get your escrow instructions, and you'll do any disclosures that you didn't do the first two times, so that it isn't so overwhelming. You're not going to sit with that buyer and do all of those disclosures at one time, unless that buyer is from out of town and doesn't have the ability to do DocuSign. Some of these forms you're just going to send over DocuSign and they'll read them and sign them. They're pretty self-explanatory.
I've spent, 45 minutes to an hour with first-time home buyers via phone, going over the documents prior to me sending them to them via DocuSign. Right. And if you have these signing parties, like what Karen is saying, following the steps of an accepted offer, at a property inspection, depending on the size of the home, you're going to have between an hour or two just waiting for the inspector to do their job. So that's a perfect time to really go over all of the other disclosures, because you're sitting across from them and it's uninterrupted.
Does that make more sense? Any other questions? This is a great time to spend that extra few minutes to answer any questions you may have, or anything that you want to know about a real estate transaction.
Yeah, because no question's a dumb question. We're all here helping one another. So please.
Okay, well, seeing none.
Okay.
Good
Going
job.
once, going twice.
I'll bite. I'll bite. I'll bite since I have you guys here. Can you guys just go over again with me the pros and cons of releasing? I know we talked about this yesterday, but the appraisal contingency, because it's a thing right now, and I just want to get my clients the house, but also protect them at the same time.
Sure. So the appraisal contingency is a big one to release, because what the appraisal does is determines value for the lender so that the lender will lend on the property. When you remove that, you're going to buy the property whether it appraises or whether it doesn't appraise. So let's just use round numbers. So say the property is going to be sold at 500 and you're going to remove the contingency of the appraisal, and the appraisal comes in at 450. Well, now the buyer has to pay that $50,000 in order to come up with the sales price for the seller, right?
Right.
The lender is only going to lend on 450. They're only going to lend on what the appraised value is. So as long as that buyer has a big enough down payment where they can take $50,000 out of it and still qualify for the loan, then they can still buy the property.
So on that scenario, if they're putting 100,000 down anyway, and it appraises for 450, what would be the downside of releasing that contingency?
Well, because if they qualify by putting only $50,000 down instead of $100,000 down, their payment might go up.
Mhm.
The other thing is they cannot not buy the property for the price of the appraisal. So no matter what, they're paying $500,000 for the property when you remove the appraisal contingency. And if it comes in short, it doesn't matter. The buyer will have to pay the difference, and the seller normally does not remove or reduce that appraised value based on the appraisal.
Okay, and so what if we get the okay with the lender, and it's a lender that we work with all the time, then would you say it's a safe bet?
Well, you just need to make sure that you're explaining to the buyer the risk involved in removing the appraisal contingency.
Right. Okay.
And the risk is that the payment may be more, and that they may not qualify depending upon the value that the appraisal comes in at.
Okay.
And if they still want to buy the property anyways and pay the difference, then you have that happen.
Okay. All right.
They just can't use it as a contingency to walk away
Right.
from the sale.
They have no right of rescission whatsoever. There's no negotiating power.
Right. And then my understanding is if they are unable to get their loan because we've done that, then that negates the loan contingency as well.
It doesn't negate the loan contingency, but most of the time when you remove the appraisal contingency, you're removing the loan contingency as well.
Inadvertently.
Okay.
Yep.
I mean, there still could be, there's definite factors that could, not based on the appraisal, could be just lost due to a loss of employment or what have you.
Sure.
So
So there's still wiggle room.
Well, if you remove the appraisal contingency and you don't remove the loan contingency,
Hmm?
if it appraises low, then you're still buying the property. If you lose your job, you're not buying the property.
Correct.
Got it. Got it. Okay.
So I guess there is a little wiggle room, Andy Pletcher.
That's my middle name, Wiggle Room.
Oh my gosh. Oh my gosh.
Okay,
in
got
this
it.
in this scenario with okay, I had 100,000 I was putting down. I find out my property, I removed the appraisal contingency. I found out my property only appraised at 450. So now $50,000 is
Cash.
not going out the window, but it sort of is. Now I really sort of have 50,000 going into, I'm no longer putting 20% down, I guess is what I'm getting at.
Correct.
True?
Right.
Which
Right.
means I'm now faced with some sort of mortgage insurance based on, depending on where I'm getting this loan.
That is a possibility.
Because I'm putting something around 10% down now. And the other 50 just went to make up the difference between the appraised value and the purchase price.
Exactly.
Exactly. That's why it's important.
Buyer.
Right. That's why it's important that everyone really realize the severity, the importance of the appraisal contingencies. All of these contingencies are there for a reason. And it's just based on the market that we're in, and people wanting their home so desperately and just literally rolling the dice. But you have to make sure that your clients fully understand what they're doing with regards to that.
And a lot of times lenders have a form within their documents that says if you remove the appraisal contingency, you're signing this form.
Yeah.
Okay.
Which releases them of liability.
Right.
Okay. We should have that
All
form
about
too.
liability, guys. It's all about the liability that you take on when you have somebody do something that's not customary.
Yeah, and we don't mean to scare the bejeebies out of you guys or
No,
anything like that. No. It's just, different scenarios are different scenarios, and different markets are different markets, and this is what we're facing now. So we just it's our job to make sure that you're fully aware on how to handle that. And of course, anyone within leadership, we're here to help you, and with the exception of Andy Pletcher. I'm totally teasing. But
Beyond help.
Oh,
All right.
she's
Thanks,
hysterical.
guys.
All right.
Thanks, guys.
So tomorrow, Karen, are we good? Are you
We are
good?
good.
Okay.
We made it through. I'm surprised that we did, but we did.
Oh, I'm so glad, and I love the Q&A. I love the interaction. So thank you for all attending. Tomorrow, we're starting on the seller documents. And Fred Tizardis should be teaching that class, but if he's pulled away on through CAR event, I'll step in for him. But tomorrow is day 1 of seller documents, day 3 of contracts, and it starts at 9. And it's the same Zoom link that you're on today. Okay? All right. Thanks all, and we will see you soon.
Thank you.
Thank you, Karen.
Oh, you're so
Thanks,
welcome.
Karen.